former Chancellor of UNSW, who over the years has taken a close interest in the UNSW Law School, I welcome this opportunity of launching the special thematic issue of the journal. It is appropriate that the venue for the launch here is at Freehills, the name by which I prefer to call the firm, because that is the name by which it was known to me before it aspired to transmogrify itself into a global monster. It is also appropriate because the support which Freehills gave the UNSW Law School in its infancy was critical to the law school's success. And as you've heard, that support has continued to this day. More so than many other university law journals in Australia, the UNSW journal is a law in context law journal. In this respect, it reflects the approach to the study of law taken at UNSW, where emphasis is given to social, political and economic influences upon the law, as well as its goals, and to the cultivation of a spirit of inquiry by independent and objective minds. The law school at Sydney, which I attended, and I say this by way of excuse, was the only law school in my day. Otherwise, of course, I would have been at UNSW. Now, the Sydney Law School was a rather different institution. Yet one of its lecturers was Frank Hutley, who ultimately became a Court of Appeal judge. He was a persistent and provocative challenger of accepted views, indeed the grand assassin of sacred cows. One opinion he gave when at the bar became the stuff of legend. He was asked by his instructing solicitor to give an opinion on the question whether the client had a cause of action in negligence against another party. Hutley's answer to the question was no, but the client has a good cause of action in negligence against my instructing solicitor. I was reliably informed that the instructing solicitor, who no doubt was taken aback by this opinion, nevertheless continued to brief Hutley and to have confidence in him. Unfortunately, the legend stops there. We don't know what happened as a result of the opinion and whether the client received satisfaction at the hands of the solicitor. Hutley was quite uncompromising. Sometimes the lawyer must be uncompromising. I have the uncomfortable suspicion that if Hutley, the barrister, gave such an opinion today, he would be blacklisted by one of these ubiquitous risk assessment committees that operates in all the major firms of solicitors. The thematic issue of the journal which I am launching this evening is directed to the public-private divide and how, if at all, that distinction has shifted in relation to law, legal practices and legal institutions, and what has caused that shift. We need to remember the divide is not a bright line. There is a large grey area incapable of definition which does not fit neatly under the rubric of public or private. When we speak of public law, we tend to think of the body of law that regulates the relationships between individuals and the state, or relates to the powers and characteristics of government and public authorities, whereas private law regulates the relationship between individuals. The divide is so imprecise that it amounts to little more than a general classification. Although it has contributed little, if anything, to the construction of legal theory, it may have inhibited developments that crossed the divide. To take the course of action in negligence as an example, because it is an element in the law of torts, we think of it as a matter of private law. That is because in a typical case, the parties are individuals. If, however, the action is against a public authority, does the law to be applied fall on the other side of the divide simply because it concerns the liability of a public authority, or because relevant to the issue of liability are the authority's powers and functions? It may well be that in a context where liability turns on the characteristics, functions and powers of a public authority, the liability of the authority stands on the public side of the divide. Yet, as you may recall, Section 64 of the Judiciary Act, like similar state statutes, sought to equate the liability of the government as nearly as possible to the liability of the individual. To take another example, if we look to the origins of our public law, much of it stems from the development of law relating to the Crown. And part of that law, in particular the immunities of the Crown, was associated with the monarch as a person. Indeed, the development of our public law involved the growing recognition that the principles of public law should be adapted to the position of government rather than the position of the monarch, as other institutions began to exercise the powers formerly exercised by the monarch, and even further to the position of a range of agencies, bodies and authorities that can be regarded as carrying on the activities of government in the broadest sense of that expression. So the area of public law has inexorably expanded with the emergence of the welfare state, and even more so with the rise of the regulatory state. Yet at the same time, public law has drawn on private law concepts and remedies in matters such as rights and liabilities, abuse of power, and the remedies of declaration and injunction. Of the 6 articles in this issue, the essay on law, governance and risk makes 3 important points. The first is the shift to the new regulatory state, characterised by privatisation and marketisation of government functions, accompanied by an increase in regulation of private actors, producing a new hybrid role for government. The second is the pervasiveness of the risk management model in the governance of modern society. The third is that this model relocates risk across sectors, very often to the individual. The authors elaborate these points in the context of climate change, water governance, flooding and bushfires. Unresolved questions of who is responsible in particular situations call for answers. Is it, for example, the responsibility of the state, local authorities or individual landowners to deal with the threat of rising sea levels or flooding? How is insurance to be managed? And what obligations, if any, should be imposed upon the insurers? And what role does the tort of negligence have to play? The author's discussion of Delaware Trading Company and Goulburn Murray Rural Water Corporation on this topic makes interesting reading. The authors conclude that the trends they have identified have severely damaged whatever utility the public-private divide had. The extent to which privatisation of government functions is being taken is illustrated by a report that the UK government is considering the privatisation of the court system to increase efficiency. The report provoked a predictable protest from the profession. The report gave no details. Presumably, it relates to court administration. The report reminded me of Ronald Reagan's statement that the 8 most terrifying words in the English language are, "I'm from government and I'm here to help." Now, as Jake Goldenfine's article in this volume demonstrates, the judicial decisions on the right of privacy are less than satisfactory. In the United Kingdom and Europe, the judicial decisions relate to the right of privacy protected by Article 8 of the European Convention. while Carapace and Victoria Police relates to the right of privacy and reputation protected by Section 13 of the Victorian Charter. The course of decisions shows a shift away from the Campbell reasonable expectation of privacy test, which was concerned with the nature of the information appropriated, to the use to which that information has been put. That is because the reasonable expectation of privacy test related to photographs and video footage and what could be derived from them, whereas later cases are concerned with the processing of images and what they may entail. So the use becomes critical. In Australia, the common law has neither recognised a general right to privacy nor developed a suite of principles across the entire subject. The Australian Law Reform Commission has proposed a legislative solution, but no action has been taken. There was much sound and fury following the Murdoch press hacking scandals. Now, however, a majestic silence reigns. Cathy Sherry's essay on Strata and community title traces the ways in which the flexibility of the legal concept of real property has led to the creation of strata title and community title to meet particular needs which straddle both private and public purposes. But flexibility has come at a price because, as applied by the courts, the flexibility disregards two fundamental limitations which represent the distillation of centuries of judicial consideration of land markets and social relations. The first limitation came in the form of boundary rules which prevented too many people having rights of veto over the use to which land can be put. The second limitation was the prohibition against annexing positive obligations to land. Breach of this rule has resulted in the imposition of unfair obligations on strata title owners where the collective entity, by means of power to make binding bylaws, imposes its own collective will on individual owners in relation to matters which should be matters of private choice. Another article discusses the construction of supported decision-making arrangements to replace traditional forms of adult guardianship for disabled persons, with a view to enhancing personal autonomy. The source of the impetus for adoption of decision-making of this kind is the UN Convention on the Rights of Persons with Disabilities. The authors suggest that in the debates about what is the optimal approach, strange assortments of public and private are being joined together. The author's main point, however, is that the current proposals are confused and may well involve the potential for abuse. With that comment, I entirely agree. I also agree with the author's conclusion that proposals for supported decision-making must be based on empirical evidence-based research and pilot programs. Both are presently conspicuous by their absence. Andrew Edgar's essay on public and private interests in Australian administrative law grapples with the three models of judicial review: the private rights and interest model, the enforcement model, and the public interest model, and explores the advantages of Australia moving towards adoption of the public interest model. The author sees some disadvantages in that model, notwithstanding that it would result in greater access to the courts through an expanded concept of standing and the development of public consultation in administrative decision-making. The main disadvantage of the public interest model is the possibility that it will blur the distinction between law and politics, a possibility which the author is very much inclined to discount. The author concludes that we should adopt that model through legislation, even though it will raise large questions for the relationship between law and politics. But after all, the relationship between law and politics is a relationship which has dogged us for a long time. Another article discusses the potential for judicial review of outsourced administrative decisions, for example, by privatised utilities. Although the modern tendency has been to move away from an insistence on the narrower notion of government power to a broader notion of public power, the courts have not yet accepted that contractually sourced power will attract public law remedies. The discussion centres on the DataFin case, an English decision, and its successors, and explores the consequences, if they are adopted here, for Australia's constitutional jurisprudence, in particular the jurisdiction conferred by Section 75(5) of the Australian Constitution. DataFin enunciated the public function test, by which the availability of judicial review of a private body is determined. It asks whether the body is in effect performing a public duty or whether the power exercised has a public element. The test prevails in the United Kingdom, and it has been approved or applied in state and territory courts in Australia. Intermediate appellate courts have, however, questioned its application in Australia. As the authors say, it has proven to be notoriously difficult to find a coherent method of delineating public from private power. And in that respect, they echo my opening remarks and, by and large, the theme of the articles in the journal. Of particular concern is the unsuitability of the DataFin test for the purposes of Section 75(5). That provision confers jurisdiction by reference to the identity of the decision-maker, officer of the Commonwealth, not by reference to the character or nature of the power being exercised. Some assistance in resolving this difficulty might be provided by Lord Justice Hoffman's suggestion, he was then a Lord Justice, that contractually sourced power could be public if the body, in that case the Jockey Club Disciplinary Committee, was a surrogate organ of government. In the light of the accepted accountability purpose of the provision, the authors suggest that construed purposefully, it can accommodate decisions made by persons to whom decision-making has been outsourced by the Commonwealth. This interpretation would depart from the natural and ordinary meaning and, in all probability, the originalist meaning of the expression officer of the Commonwealth. It is legitimate, however, to give a strained interpretation to words in order to give effect to a purpose, particularly a constitutional purpose. The authors also point to the Canadian view that a private body that is an agent of government or is directly controlled or influenced by a public entity may be subject to public law. Certainly there is a case for saying that a decision-maker who is an agent of the Commonwealth falls within the scope of 75(5). The test is narrower than the Hoffman surrogate test. Now, in conclusion, it can be said that the 6 articles, all of high quality, demonstrate that the problems caused by the rise of the regulatory state further expose the inadequacies and uncertainties of, and the lack of utility in, the public-private divide.
I get the lucky job of coming up to say some thank yous as Dean of the Law School. I love to claim credit for the Law Journal, even though it's been pointed out that it is entirely a student-owned and led journal, and that's something of which we're very, very proud. three thank yous. Firstly, to everybody who's been involved in the journal. As Quentin Digby said, this is a good place for law firms to be looking for top talent. The journal always attracts the very best of our students, and this year is absolutely no exception. It's a wonderful team, and I think that they've done a great job in putting together the